Picture two courtrooms. In the first, a man is on trial for murder. In the second, a woman is suing her business partner for fraud. Same building, same judges in robes. But the rules for who has to prove what, and how convincingly, are completely different. Get these rules wrong, and an innocent person goes to prison, or a guilty one walks free. They are the hidden machinery beneath every single case in the country. These are the two most important concepts in the law of evidence: the burden of proof and the standard of proof. Master these two ideas, and you understand how every trial in Australia actually works. Let's get into it. Every case, criminal or civil, has to answer two separate questions before anyone can win. Question 1. Who carries the burden? That is the burden of proof. It asks, whose job is it to actually prove the case? Because here is the key idea. If you are the one who has to prove something, and you fail to prove it, you lose. The burden tells us who bears that risk. Question 2. How convincing must the proof be? That is the standard of proof. It asks, how sure does the decision maker have to be before they can find that something is true, almost certain, or just more likely than not? Keep these two questions separate in your mind. Burden is about who. Standard is about how much. Let's take them one at a time. The burden of proof is the obligation to prove your case. And the starting principle is simple. Whoever brings the claim carries the burden. If you assert something, you prove it. The person making the allegation has to back it up, not the other way around, carries the burden. The accused does not have to prove their innocence. They do not have to say anything at all. This flows directly from the presumption of innocence, one of the deepest principles in our legal system. You are presumed innocent until the state proves otherwise. The burden sits on the state, and it never shifts to the accused to prove they didn't do it. Now, lawyers actually split the burden into two layers, and this is worth understanding. The first is the legal burden, sometimes called the persuasive burden. This is the ultimate obligation to prove the fact in issue. In a criminal case, that legal burden stays on the prosecution from start to finish. The second is the evidential burden. This is a lighter preliminary task, simply the obligation to point to enough evidence to put an issue on the table. For example, if an accused person wants to raise self-defense, they carry the evidential burden of pointing to some evidence that raises it. But, and this is the crucial part, once they do, the legal burden remains on the prosecution to disprove self-defense beyond reasonable doubt. The accused raises it. The state must defeat it. In a civil case, the person bringing the claim, the plaintiff, carries the burden of proving the elements of their claim. If the defendant raises a defense, they carry the burden of proving that defense. So the burden can sit on different parties for different issues in the same case. The guiding idea throughout is the same. He who asserts must prove. So we know who has to prove the case. Now, how convincing does that proof need to be? This is the standard of proof, and here is where criminal and civil law split dramatically. In criminal law, the standard is proof beyond reasonable doubt. This is the highest standard known to our legal system. The jury must be sure of guilt. If they are left with a reasonable doubt, a real, rational doubt based on the evidence, they must acquit. Why so high? Because the consequences are so severe. We are talking about taking away a person's liberty, branding them a criminal. Our system makes a deliberate moral choice here, often expressed this way. It is better that a number of guilty people go free than that one innocent person be wrongly convicted. The high standard is the price we pay to protect the innocent. In civil law, the standard is the balance of probabilities. This is codified in Section 140 of the Evidence Act 1995. It means the court must be satisfied that the party's case is more probable than not. Put simply, more likely than not. If you imagine a set of scales, the evidence only has to tip them past the 50% mark. Just over the line is enough. Think about the gap between these two. In a civil case, 51% wins. In a criminal case, 51% is nowhere near enough. You need to be sure. That is why a person can be acquitted of a crime, but still lose a civil case arising from the very same events. Different standard, different outcome, same facts. It is not a contradiction. It is the system working exactly as designed. The logic is about what is at stake. In criminal cases, it is your freedom, so we demand near certainty. In civil cases, it is usually money or property being shifted between two private parties who stand on equal footing. So we simply ask which side is more probably right. Let's make this concrete. Imagine a car accident. A pedestrian is struck and injured. First, the criminal angle. The police charge the driver with dangerous driving. Here, the prosecution carries the burden. They must prove, beyond reasonable doubt, that the driver drove dangerously. If the jury has a reasonable doubt, maybe the pedestrian stepped out suddenly, maybe the evidence is unclear, the driver is acquitted. Not because everyone is certain they were innocent, but because the state did not reach that very high bar. Now the civil angle. The injured pedestrian sues the driver for negligence, seeking compensation. Here, the pedestrian, the plaintiff, carries the burden, and they only have to prove negligence on the balance of probabilities. More likely than not, the driver was careless and caused the injury. So you can see how the same crash produces two cases, with two different people carrying the burden, judged by two completely different standards. The driver might walk free from the criminal court and still be ordered to pay compensation in the civil court. Same event, two verdicts that only look contradictory until you understand burden and standard. This isn't just theory for law students. These two concepts decide real outcomes. They are why the state has to build an overwhelming case before it can convict you. They are why, in a dispute over a contract or an injury, the person making the claim has to actually back it up. Burden and standard are the rules that keep the system fair. They put the risk of failure on the right party, and they set the bar at the right height for what is at stake. But here is where it gets really interesting, and this is what we cover in Part 2. What happens in a civil case when the allegation is genuinely serious? Say, fraud or sexual misconduct. We still use the balance of probabilities, just more likely than not. But does that feel right? Should an allegation that could destroy someone's reputation really be provable at just 51%? That tension is exactly what the High Court grappled with in a famous 1938 case called Briginshaw, and the principle that came out of it shapes serious civil cases to this day. That's Part 2. If this made these two ideas click for you, subscribe. Part 2 on the Briginshaw principle is the perfect next step. Drop a comment with any questions, and I'll see you there.